Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Once again, the topic of Collegium system has come into, actually, it has become a play between the judiciary as well as the legislature. Actually, you may be knowing, during the year 2015, the central government or Union of India brought National Judicial Appointments Commission Bill, which was ratified by both the Rajya Sabha and Lok Sabha. But when it was reviewed by the Honorable Supreme Court of India, Supreme Court said no for this act, NJEC Act. So, once again, the so-called Collegium system has come into existence. The difference between NJAC and the Collegium is only 2 points. In Collegium, the Supreme Court Chief Justice of India will be assisted by senior judges. 4 senior judges, all of them will sit together on some day and they will decide the appointments like posting, transfer, elevation, promotions, all these things. And they will send the recommendation to the Government of India, who in turn will give the so-called appointments as per their actually it has got a consolidated effect on the financial matters also. So they will slowly give the so-called appointments. So when the Collegium system, so this is the Collegium system. Then what is the NJEC, National Judicial Appointments Commission? They wanted to follow the judicial system, Collegium system, but they wanted to add law minister plus 2 efficient or proficient people in the so-called judiciary. Or, of course, if I say A is a proficient fellow, A is a skilled person, they have to accept. So they want to add 2 persons plus the law minister or the home minister. So ultimately, the independence of the judiciary is being affected in the opinion of the Supreme Court. Therefore, they said no, NJAC. So the Treasury, no doubt, okay. For that, at the 2015, the matter has been subsided. Nobody is commenting. Very recently, there was a tussle between the judiciary and the legislature. It sparked off when our law minister, Kiran Rijiju, who himself is a lawyer from a famous institute called as Hansraj College of Law. So he stated that the center cannot act like a post office. They have to think over the matter. So normally what they have to do, the Collegium recommends the elevation of certain advocates as high court judges, or certain judges to be transferred, certain judges to be promoted, things like that. Then Kiran Rijiju says, is the government there only to act as a post office? Can't they have any say in the appointments? We are elected by the people. We are the public representatives. We must have a say. This is his opinion. Okay, the opinion. Then immediately Supreme Court retorted. The Honorable Judges Supreme Court stated that people in responsible positions should not talk like that because of the independence of the judiciary. Then, not only Kiran Rijiju, very recently, the Honorable Vice President of India, Jagdeep Dhankad or somebody, previously worked as West Bengal governor. So he also stated that ours is a democratically elected government. The bill has been passed by the Lok Sabha and Rajya Sabha. So what is the great difficulty for the Supreme Court to allow the bill? Are we not the representatives of the people? So why these MLAs or MPs, why these MPs are not touching the subject? Why they are again keeping silent? So to sum up, Jagdeep Dhankad's issue is that the Parliament is supreme. Supreme Court cannot negate the so-called bill passed by the so-called legislature, the Parliament and Rajya Sabha. So now once again the issue has come up. So yesterday, actually, while disposing the case of the Advocates Association Bangalore versus Sri Varun Mitra. In this case, actually, the 3 judges bench, Sanjay Kishan Kaul, Abhay Voka and Vikram Nath. So while dealing with this this is actually a contempt petition. This is the Advocates Association Bangalore versus Sri Barun Mitra. This is a contempt petition where it is also regarding judicial officers' appointments. Right. So in this connection, actually, the Advocates Association wanted the so-called action, contempt action to be taken against the Union of India because they have breached the timeline given for the judicial appointments. Of course, this petition or public interest case was filed in the year 2018 and it has come up on some other petitions but also mixed. Now, in this connection, please remember the issue of Jagdeep Dhankar and Kiran Rijiju. It has come up in a mixed way. Now, Honorable Supreme Court bench says, the scheme of the Constitution requires the court to be the final arbiter of law. I have been telling you number of times. So, Supreme Court is the guardian of the Constitution. Supreme Court is the final arbiter of law. Right? The power to enact law, definitely it is with the Parliament. The state, they can make any law. But please remember, it is important that the law of the court, the judgment of the Supreme Court is to be followed. Because Supreme Court will decide, Supreme Court will review. No doubt, the term judicial review is not found in the Constitution, but it has been adopted from the USA. The Supreme Court has got the power to interpret, it has got the power to review, it has got the power to say whether the act is in consonance with the Constitution or not. So, the law of the court is to be followed. Otherwise, what will happen? People, the elected people, the mass majority people, they think that they will follow the law which they think is correct. We have got 107. Very recently, Gujarat got 156 out of 180 or so. Then they say, yes, we can make the law. We follow the law. What do we think? Is it correct? No, not at all. So, please remember, sometimes, normally, if the government is cooperative, they will act very soon. Sometimes there will be definitely kept pending. We have seen the case of Justice Akhil Qureshi or Justice K.M. Joseph. No doubt, when the Supreme Court has compulsorily made that Justice K.M. Joseph has to be promoted to the Supreme Court, then he was promoted lately, as a result of which he became a junior to his batchmate. This is another important issue, right? Ultimately, Supreme Court told the AG to inform the center that Collegium system, it is the law of the land. That's all. Collegium system is the law of the land and it has to be followed to the teeth. It has to be followed in letter and spirit. Just because there are some sections who express some views like Vice President or the Home Law Minister, Central Law Minister, since they express views against Collegium, it will not cease to be the law of the land. You have to follow the law of the land. Right? Please remember, it has advised the Advocate General to inform the authorities or the government. It is not good to make comments on the Supreme Court Collegium. It is not very well taken. You have to advise them to control. This is what they have informed the Advocate General. Of course, Advocate General stated that he will consult the concerned persons and apprise them of the situation. So, this is regarding the Collegium system, the controversy. So, 2015 judgment we have discussed. Of course, everybody will have grouse because this dispute has been always there between legislature and the so-called judiciary. So, nu goppa anukuntuntaru. As advocates, so Collegium system is the best one. And of course, it is the only system in India. మిగతా ప్రపంచంలో ఎక్కడ లేదు. ఇప్పుడు అమెరికా ప్రెసిడెంట్ అంతా వాళ్ళు పొలిటికల్ పోస్టింగ్ ఇచ్చేస్తూ ఉంటారు. కానీ వాళ్ళలో గొప్పతనం ఏంటంటే when once they assume charge, they will be totally independent. Anyway, this is regarding the present scenario or the conundrum on the Collegium system. I think I have explained you. Please read the newspapers and enrich your legal knowledge on the Collegium system. With this, I am concluding. Thank you very much.